Imagine you awaken from a deep sleep and discover that you committed a violent crime against another person while you were sleeping. If you were charged with that crime, would you have a defense? The Washington Court of Appeals addressed this issue in State v. Utter. Claude Utter and his son lived together in an apartment. One day, his son entered the apartment and was heard saying, quote, "Dad, don't," unquote. Shortly thereafter, the son stumbled out of the apartment, bleeding from a stab wound in his chest. He collapsed and died. Claude Utter was charged with second-degree murder in state court. At Utter's jury trial, he testified that he had no memory of the stabbing. He admitted that he had been drinking large amounts of wine and whiskey that day. He further testified that he had served for 4 years in the infantry in World War II. He had been trained in jungle warfare. Part of that training was to respond immediately to threats. Utter also offered evidence that twice since his military service, he'd involuntarily reacted in a violent manner to people who'd approached him unexpectedly from behind. A defense psychiatrist testified that Utter had stabbed his son as a result of a conditioned response from his military training and combat experience. The trial court refused to submit an instruction to the jury that, if it found that Utter stabbed his son involuntarily as a conditioned response, it should acquit. The court instead instructed jurors to disregard all of Utter's evidence concerning it. The jury convicted Utter of the lesser offense of manslaughter. Utter appealed to the Washington Court of Appeals.